May I please, Your Lordship?
Yes, please.
My Lord, I beg to mention hearing item number 42. Kindly pass over the day, for the day, my Lord.
No, tomorrow. Tomorrow we are on a journey.
Monday, my Lord.
Not Monday. Tenth, on the prayer of Mr. E. Tiba, Om, Learned Government Advocate, listed on 10/10/2023. Okay.
Much obliged.
For admission, item number 1.
Please, Your Lordship.
Yes,
Lordship, here I'm appearing for respondent number 6, Lordship.
yes.
Lordship, I'm yet to receive the Paraguay's comment. So if I may be granted another 3 weeks time, Lordship.
Therefore, what about government?
Government is
Okay. Therefore,
respondent number 6, Lordship, the private respondent. I was entreated, Lordship,
on the prayer of M.S. Lucino, the learned counsel for the respondent number 6, listed after 2 weeks.
Lordship.
Obliged.
For admission, item number 2.
May I please, Your Lordship?
Yes,
My Lord,
please.
here I'm yet to receive clarification from the department. So kindly allow me 3 weeks time.
Okay.
Obliged.
Mr. E. Tibapom, the learned government advocate, 6 for 2 weeks' time to file affidavit in opposition. Prayer is allowed, listed accordingly.
Much obliged.
For admission, item number 3.
Your Lordship,
Yes.
still has already filed additional
Who is for the petitioner?
petitioner.
Who's for the petitioner? Okay. None appears for the petitioner, listed after 3 weeks.
For admission, item number 4.
Yes.
Sir, Lordship, apologies, Lordship. Lordship, none of the parties have filed their counters.
Okay, what happened?
Your Lordship, this matter pertains to appointment of Ganesh Captain. So now, issue has been, the main issue is between the petitioner and the private respondent. Private respondent is not present today.
Yes, Lordship.
The state has nothing much to say.
Lordship,
It is the judgment order passed by the district judge. The petitioner has put this petition.
I think this should be listed before another bench.
Lordship,
Listed before any other bench without me.
For admission, item number 5.
Your Lordship status to verify the affidavit.
Yes, where is the petitioner, counsel for the petitioner? What is the case about, ma'am?
Lordship, it's about the petitioners they were terminated from the post of GP. So they're challenging the termination order.
So it is stayed.
No, Your Lordship, it is not stated.
Just see 26/5/2022 whether
Next, Lordship. Lordship, here.
I was just about to vacate the interim order.
Lordship,
UPA cost.
Lordship, I mean, able to mount submission, Lordship.
Yes.
The revised cost list was only seen just this morning, some 5 minutes ago. Lordship,
Pardon?
kindly allow me some time to file my Lordship.
No time. No time. Since 13/3/2023, you have been seeking time to file reply.
Lordship,
Either you pay cost or vacate the interim, whichever, the option is yours. We cannot allow you to go on like this, sitting over the interim.
Lordship, I was informed that the petitioner was not keeping well, that's why we could not execute signature. One time maybe granted, Lordship.
Mr. Fuseko, the learned counsel for the petitioner submits that he may be allowed some time to file affidavit in reply. Stop. It appears from the orders passed by this court that the learned counsel for the petitioner has since 13/3/2023 sought time to file affidavit in reply. but the affidavit has not been filed till date. Prayer by the learned counsel for the petitioner to file affidavit in reply is accordingly rejected. Listed for hearing in the usual course. Okay.
What's the intending to continue?
This court is not willing, in fact. The interim order passed earlier shall continue till the next returnable.
Will you reply, sir?
For admission, item number 6.
Yes, Your Lordship.
Yes.
Your Lordship, here I've sent the affidavit for vetting. So kindly let this matter be listed after 2 weeks, Your Lordship.
Okay.
Yes, Your Lordship. No objection.
MSc Naoli, the learned government advocate, submits that the affidavit in opposition has been sent for waiting of the department. Then accordingly seeks for 2 weeks' time to file the affidavit. Prayer is allowed, listed after 2 weeks.
For admission, item number 7.
Yes, Your Lordship.
Yes.
Kindly grant me 1 week to file my affidavit in reply.
MS Swenso, the learned counsel for the petitioner, seeks for a week's time to file affidavit in reply. Prayer is allowed, listed accordingly.
For admission, item number 8.
Your Lordship, I'm
Yes.
sending on behalf of my senior, Joshua Shike. If Your Lordship may kindly fix this matter on Monday.
It was for the government. What is the matter about? What is the matter about? Pleadings complete.
Your Lordship, hi, I am not in this matter, Your Lordship. So
Pleadings completed.
No, Your Lordship. Your Lordship, since this morning, because it's been just received 5 minutes earlier, so we didn't bring the file, Your Lordship. If Your Lordship may file on, or we fix this matter on Monday.
Your Lordship.
State.
Yes, we have not received any instructions as yet, Your Lordship. I've sent them regular reminders.
Are you appearing? Are you appearing in this case?
Yes, for respondent 1 and 3.
1 and 3.
But I believe respondent 2 and 4 are the main parties, Your Lordship.
What is the matter about?
The land ownership appointment.
land ownership appointment, how can the electoral officer be the main party?
The office is in the election office, and that's what the petitioner claimed.
You file your affidavit.
Mr. Lordship.
Who is for 2 and 4? 2 and 4.
Not very sure. Well, this file was endorsed to me just recently, Your Lordship.
That's okay, that's okay. Z Kulnu. Okay. Mr. So-and-so, the learned government advocate, seeks for some time to file affidavit in opposition on behalf of respondent number 1 and 3. Stop. Prayer is allowed. Listed after 3 weeks.
Objection, Lordship.
For admission, item number 9.
Yes, my lord. My lord, I filed my reply this morning.
Okay. Who's for the other side? What is the matter about?
My lord, I'm seeking for regularizations of the service and pension benefits of the petitioner.
Pleadings are completed. List the matter for hearing in the usual course.
Okay.
For admission, item number 10.
My lord, even here I filed this morning.
Same.
Yes.
Yes, same order. Even item 11.
My lord, I may be allowed 3 weeks time to file my reply, my lord.
11, item 11.
For admission, item number 11.
Okay, reply. Mr. Likase, the learned government advocate, is allowed 3 weeks time to file affidavit in reply, listed accordingly.
Okay, sir.
For admission, item number 12.
May I please, Your Lordship?
Yes, please.
Your Lordship, we are yet to receive instructions to file our affidavit in reply, so can you give us 2 weeks time?
Okay. Your good name, please?
Asmala.
Ms. Asanla, the learned counsel for the petitioner, seeks for 2 weeks time to file affidavit in reply. Prayer is allowed, listed after 2 weeks.
For admission, item number 13.
Who is respondent for?
May I please, Your Lordship?
Yes.
Lordship, my senior is he's leaving the other court, so.
What is the matter about?
It's pertaining to the nominee,
Oh,
inclusion of the nominee.
have you brought the instructions? Who was?
Lordship, let this matter come out after some time.
Because Lordship, in the last order, the petitioner counsel was directed to give the gist of the case. Because as far as my part is concerned, Lordship, I've already explained the OM, where how the nominee can be included. Because her name was not there because the husband's family intentionally did not put her name in the action, in the PPO. In fact, the matter has been heard at land law. The petitioner was directed to produce the gist of the case.
Where is the gist?
Mr. Yamawati is on his foot in the lawsuit. So after the addition, I can lawsuit.
Yeah, no, Mr. Muzi,
Lawsuit.
order 14/9/20, last it was listed on 14/9.
15/9 lawsuit.
14/9.
15/9.
It's 14/9.
On third, again, it was listed.
Third, where is the third order? Oh, listed again on.
Yes, because the matter was to be listed,
I don't see any gist.
Mr. Counsel for Petitioner was directed to give the gist of his case.
Subject index. Let us just.
Lordship, let it matter come after the admission item motion. Since Mr. Yamawati is understood important.
Yes, I'm just. Okay, revised list.
Let's go.
Yes.
For admission, item number 14.
Yes.
Lordship, I am representing the state here. Lordship, I may allowed another 3 weeks ago, Lordship, for the state council.
What is the matter about, Mr. MP?
This relates to village council, Your Lordship.
Village council. Village council? There are so many issues in a village council. What is the issue here?
This between 2 villages. Land dispute.
Oh, land dispute between two villages. Okay. Okay, you file your, what about the, are you for?
Lordship, and for respondent number 5.
Have you filed your affidavit?
No, Lord.
Okay. So file it. Mr. Moimchan, the learned senior government advocate, and Mr. So-and-so, the learned counsel for the respondent number 5, 6 for 3 weeks' time to file their respective affidavit. Prayer is allowed, listed after 3 weeks. Yes.
For admission, item number 15.
Yes.
Your Lordship, sometime may be given, Your Lordship.
Where is the counsel for the petitioner?
Your Lordship, I think since this is a revised course list, so like,
Revised course list.
yeah, that's why many has overlooked me.
Okay. Okay. Sapum Cham. MS Livika, the learned government advocate, 6 for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 3 weeks. Okay.
Much good.
Item number 16.
Yes, Mr. Likase.
Please, my lord. My lord, in this matter, I may be allowed 3 weeks simplified reply, my lord.
Mr. Okay, Ms. Mary. Mr. Likase, the learned counsel for the petitioner, is allowed 3 weeks' time to file affidavit in reply. Listed accordingly.
I have pleasure.
For admission, item number 17.
May I please, my lord?
Yes, please.
Your lordship, may kindly grant me 3 weeks time to file my counter affidavit. I am yet to receive instruction in this matter, your lordship.
Okay.
No objection.
Mr. N. Angami, the learned senior government advocate, is allowed 3 weeks' time to file affidavit in reply. Listed accordingly.
Deeply obliged, my lord.
For admission, item number 19.
Lordship, I have a similar prayer even in this matter, your lordship.
This is,
Item number 18, my lord.
Sorry, item number 18.
okay. Same order, as in 17.
Deeply obliged, my lord.
Yes.
Obliged.
For admission, item number 19.
Petition motion.
Yes.
Your worship, I'm not completing my affidavit. So 2 weeks time will be done.
Where is the counsel for the petitioner? None appears for the petitioner. Mr. Im Timson, the learned additional advocate general, is allowed 3 weeks' time to file affidavit in opposition.
For admission, item number 20.
May I please, your lordship?
Yes.
Your lordship, kindly allow me 2 weeks to file my affidavit in reply to the affidavit filed by the state respondents.
Okay. Ms. V. Thierry, the learned counsel for the petitioner, is allowed 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state. Listed accordingly. Okay.
For admission, item number 21.
Yes.
Bless your lordship. Your lordship is relates to the release of the village development fund.
Oh. Yes, have you released?
No, your lordship,
We'll call the deputy commissioner.
no, your lordship, it is like this. There's some issue here. Because some of the villages were displaced and they are in the Shamarpur district, which is a district now. So that is the difficulty.
At least disperse the fund to those persons who are in the village at least. You are always bringing one excuse or the other.
No, your lordship, it is not like this.
We'll call the deputy commissioner. We'll tell him to explain. You are not able to explain properly.
No, your lordship, what happened is, it is a very long history of dispute between two communities.
Last time, what did you submit? This court is recorded.
That is why, your lordship, last time, so far as the village, in the Chandang settled villages has been concerned, it has been identified. But those displaced persons who are in Shamarpur district, those has to be identified.
We'll call the deputy commissioner. Let him explain. We'll call the deputy commissioner.
2 weeks time, lordship. Please. Because,
You are always bringing up excuses.
no, your lordship,
What no?
your lordship,
This court says yes. You are always bringing up excuses as per the record.
no. This, under the Dunshan district, it has been identified in this village. Now, some
Give me a date when the beneficiaries will get the benefit, the development fund. Give me a date. I will record that. And if on that day You do not disperse the development fund, we'll call the deputy commissioner. You give me a date. I'll actually allow adjournment only under condition. Give me a date.
Lordship, from about 2 weeks.
Give me a date.
Lordship, this will come up on 30th
30th of?
October.
We are recording
Lordship,
that we are calling the deputy commissioner on 30th if the development fund is not dispersed. We are recording that. Heard MS so-and-so, learned counsel for the petitioner. And Mr. Moimchin, the learned senior government advocate for the state respondents. On 29/8/2023, after hearing the learned state counsel, it was ordered that on the next date fixed, the learned government advocate shall come with clear instructions as regard the payment made to the job card holders, failing which it was observed that this court shall consider seeking the personal appearance of the concerned deputy commissioner before the court to allow the deputy commissioner to explain as to why the funds have not been released to the beneficiaries. Stop. Today, when the matter is listed, Mr. Moimchan, the learned senior government advocate, gives an assurance to the court that the funds shall be dispersed to the beneficiary job card holders. We'll give you more time on or before November 7/11/2023. And accordingly seeks adjournment of the case. Stop. On the prayer made by the learned senior government advocate and considering the order dated 29/8/2023 passed by this court. This court grants time till 7/11/2023 to the deputy commissioner to disperse the funds to the beneficiaries. It is made clear that if the funds are not dispersed as directed by this court, the Deputy Commissioner, which Deputy Commissioner?
You sign.
The Deputy Commissioner Tueng Sang shall give his personal appearance before this court on 13/11/2023 to explain to the court as to why the developmental funds could not be disbursed to the beneficiaries. Listed on 13/11/2023. A copy of this order shall be furnished to the Deputy Commissioner Tueng Sang through the learned senior government advocate. Okay.
Obliged.
For admission, item number 22.
Yes, Mr. Kiangami.
Lordship, I'm yet to receive instructions, so can you grant me 3 more weeks time, Lordship?
Okay. Yes,
And for the private respondent number 6, we have already filed our.
Mr. Kiangami, the learned senior government advocate, 6 for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed. Listed after 3 weeks.
For admission, item number 23.
May I please, Lordship?
Yes, please.
Lordship, I have instruction to appear on behalf of Mr. Pakin, counsel for the petitioner.
Pakin.
Lordship, we have received the affidavit in opposition filed by the government.
You are one of the counsels?
No, man. I have instruction to appear on his behalf. Lordship, kindly grant me it's time to file the affidavit in reply.
Status file?
Yes, Lordship, I'm not appearing in this matter, Your Lordship, but. Your Lordship, I've been informed that she has filed, Your Lordship.
Mr. So-and-so makes a mention on behalf of Mr. So-and-so, the learned counsel for the petitioner, and 6 for
3 weeks' time.
3 weeks' time to file affidavit in reply. Prayer is allowed, listed accordingly.
Please, you oblige, Lord.
For admission, item number 24.
Your Lordship, state has already filed the affidavit.
Okay. This for the petitioner. What is the matter about, ma'am?
Your Lordship, petitioner seeking regularization is a work charge. Okay.
You file your affidavit.
Yes, Your Lordship.
None appears for the petitioner. The pleadings are completed. Listed for hearing in the usual course.
For admission, item number 25.
Your Lordship, similar query also. State
Okay.
has filed the affidavit.
Similar. The same petitioner.
Yes, Your Lordship, same petition.
Same petitioner.
For admissions, item number 26.
Your Lordship, affidavit is under preparation, so kindly grant me some more time.
Let us see the file. What is the additional affidavit which the state proposed to file?
No, Your Lordship, not additional affidavit.
What is that on the prayer of Mr. K. Angami Leonard Sinha?
That has been
State Council?
mistakenly typed, Your Lordship.
Okay.
Just the affidavit in opposition.
Affidavit in opposition. Okay. You are appearing in this case?
Yes, Your Lordship.
MS KIME, the learned government advocate. 6 for 3 weeks' time to file affidavit in opposition. Stop prayer is allowed, listed after 3 weeks.
May I please, Your Lordship, there is interim.
The interim order passed earlier shall continue till the next reasonable date.
For admission, item number 27.
Your Lordship, here also if I may be given 3 weeks time to file my affidavit.
MS AIME, the learned government advocate, is granted 3 weeks' time to file affidavit in opposition. Stop. Prayer is allowed. Listed accordingly. Listed accordingly. Not prayer is allowed. Prayer is allowed. Cancel. Listed accordingly.
For admission, item number 28.
Yes. What is the matter, Mr. Sherry?
Lordship, this is with regard to the work I have done without work order.
Yes. What is the instruction?
They filed the affidavit.
What is?
They have admitted it.
When can the additional funds be released?
Lordship, you will find in paragraph 5 of my state contract.
I am actually asking you the question from para 5. When can the government release the additional fund? Because it is an admitted fact. You have admitted.
Yeah, yes, well.
So when-
Lordship is well aware of the fund constraints of the development, and it is more than 1 crore, 1.70,
Uh,
1.70 lakh.
uh,
So,
but you are using the road.
I'm using the.
Then don't use. If the fund is too much, don't use.
No. Okay, will use, but there's a fund constraint only. Otherwise, the government is proceed. But then, the lordship, give us some time.
You know, to assess the government, the contractor has actually shelled out the money from his pocket. Now at least you repay that money, and I think fund constraint is not a good ground to actually like deny him what he has spent. He has spent. You are using the road. Then don't use the road.
Lordship, give us some time so that we'll be able to make the payment to the petitioner.
We give some time.
Lordship,
We'll record that. You are actually seeking for some time to make the payment to the contractor or to the petitioner. Okay, we'll record that. See, Mr. Moa, kindly tell the government, kindly tell the department that this man has spent so much of money and then he has actually constructed the road. The government is allowing the public to use the road. So at least pay him back. It is not that the petitioner is asking something in advance
I agree, Your Lordship.
to undertake the work.
I agree.
The petitioner is asking what he has spent and which is admitted by the government. So at least in such cases, I think the government should also not always take that excuse, fund constraint. I think that should not be an excuse every time in such cases. So you take steps, you instruct the government to pay him.
But his prayer for interest, Your Lordship, it is very impractical.
See, if you are instantly, if you can give me a date today, saying that you will pay him within a week or two, you give me a date, then we will waive the interest. If not, you have to pay. You continue saying that actually we will not be able to pay now because we are fund constrained, and you also come before this court saying that at least waive the interest part. That cannot.
There was no agreement for that.
There is no agreement, but it is implied. It is implied that the interest has to be given because actually he has spent his money. It is not that you have given him something in advance and then he has used that money. So,
Your Lordship allowed to stay 3 months' time without interest.
I think you give a date to pay him the principal, then after that we will see the interest.
Within 3 months' time, Your Lordship.
Lordship, 1 month time may be given because we have been waiting since 2016. 15 we have completed a work. And 2016 onwards only they are saying that fund constraint, blaming one another. This practice is going on. And same thing, even before the court they filed the affidavit, same stand they are taking that fund constraint. So intention of the government doesn't seem to be very good, Lordship. So I pray that a strict direction may be given within a specific time, let them pay and with interest. 9% per annum, as per the prevailing bank rates.
We give you 2 months time. Make the payment. Okay? Third, Mr. Sharif Ahmed. the learned counsel for the petitioner, and Mr. Moimchit, the learned senior government advocate for the state respondents. Mr. The learned senior government advocate submits that the state may be allowed 2 weeks' time to make the payment to the petitioner.
2 months time.
2 months, 2 months. We're giving. So, an assurance is also given by the learned senior counsel that every endeavor shall be made to pay up the liability of the petitioner within the period of 2 months.
Date may be fixed, yeah.
Stop. Prayer of the learned senior government advocate is allowed, and the state is granted 2 months' time to clear up the liability of the petitioner, which is claimed in the present writ petition. State, stop, listed again on (412). 412, listed again on 4/12/2023. Mr. Moa, we are giving you sufficient time, huh? Because this court always remembers the date. We are giving you sufficient time. So kindly take steps. Okay? A copy of this order shall be furnished to the learned senior government advocate for taking necessary steps with the department.
For admission, item number 29.
Yes, my lord.
Yes.
Can you grant me 3 weeks time to file counter motion?
What about any other private respondents?
Yes, respondent number 6, 7, and 8, Lordship.
Have you filed?
No, not yet, Lordship.
Okay, ma'am. Mr. K. Angami, the learned senior government advocate, as well as Mr. So-and-so, the learned counsel for the respondent number 6, 7, and 8.
Yes, sir.
6 for 3 weeks' time to file affidavit in opposition. Prayer is allowed, listed after 3 weeks.
For admission, item number 30.
Mr. Lordship.
Yes.
Lordship, I'm making a prayer on behalf of Tibapom, Your Lordship. Here he's here to file counters of any grant 3 weeks time, Your Lordship.
The learned government advocate is granted 3 weeks' time to file affidavit in opposition. Okay.
Much obliged.
If you apply.
For admission, item number 31.
Lordship, given here I'm yet to receive instructions, so can you grant me 3 weeks?
Who is for the petitioner? Okay. So this is regarding the transfer. Arey, yeah, just I think 2-3 lines affidavit will suffice.
Instruction.
He has been transferred and the order has not been revoked and he is still allowed to stay in that place. No? This is like that case.
No, he is already transferred.
He is already transferred. Mr. Kiangami, the learned government advocate, is allowed 3 weeks' time to file affidavit in opposition. Okay.
That should go.
For admission, item number 32.
Yes, ma'am.
Your Lordship, can you grant me 3 weeks time to file a counter, Your Lordship? 32 and 33, Your Lordship.
In item this in the item where Mr. Kiangami was appearing, correct? In the first item where Mr. Kiangami was appearing just now, none appears for the petitioner. Yes, what is this?
Your Lordship, I'm yet to file a counter, so can you grant 3 weeks time?
What is this case? Okay. None appears for the petitioner. MS Inauli, the learned government advocate, is allowed 3 weeks' time to file affidavit in opposition.
For admission, item number 33.
Similar prayer, Your Lordship, in item number 33, Your Lordship.
None appears for the petitioner. Same.
For admission, item number 34.
None appears for the petitioner. None appears for the parties. Listed after 4 weeks.
For orders, item number 35.
Worship, kindly allow me 2 weeks' time to file a affidavit on subsequent verification report.
Affidavit on
Subsequent verification report.
subsequent verification.
Yes.
Whether subsequent verification has been
There
conducted.
was a correction to go for the verification of the.
So whether it has been conducted,
Your Lordship,
whether subsequent verification has been conducted. Where is that order, Mr. MT?
Your Lordship, today I was confused because it was not in the first
Ah.
first list, so I don't bring my report.
Mr. MT, so rectified joint verification. That he may be. You were supposed to file affidavit on the rectified joint verification.
Yes, yes, that one.
Yes, ma'am.
yes, Your Lordship, for the petitioner, this matter is an urgent matter, so also joint verification has been done, so can we fix the matter in the coming week?
What is the urgency?
Said that, Your
What is
Lordship,
the urgency?
Your Lordship, that I will consult my senior. Yes.
Are you, what is
Actually, the cost list has been revised, so
No,
my
the
senior
process has been
was-
revised. You were saying there is urgency. What is the urgency? You said you will consult your senior. I think that is not the right
That's what my
matter
cons-
submission.
my senior consult me.
Mr. M. Timsu,
I'm from respondents 1 to 3.
you have filed your, okay. Mr. M. Timsu, the learned additional AG. Is granted 3 weeks' time to file detailed affidavit on the rectified joint verification report as ordered by this court on 12/9/2023, listed after 3 weeks. Okay.
For orders, item number 36.
We have Mr. Lordship.
Yes.
Madam, kindly allow me 3 weeks time to file affidavit.
Okay. And you, ma'am,
For the respondent number 5.
have you filed your affidavit?
No, Your Lordship.
You won't file.
Can we allow 3 weeks time to file it?
Mr. E. Tibapong, the learned government advocate, as well as MS Swenso, the learned counsel for the respondent number, 5. 6 for 3 weeks' time to file the respective affidavit in opposition. Prayer is allowed, listed after 3 weeks, okay?
For orders, item number 37.
My lord, I have a similar brief.
None appears for the petitioner. Stop. Mr. E. Tibapo, 6 for 3 weeks' time to file affidavit in opposition. Prayer is allowed, listed after 3 weeks.
My lord.
For orders, item number 38.
Please, Your Lordship.
Yes, please.
Lordship, here, I have been informed that there has been a settlement between the parties, Lordship.
Very good.
Here, Lordship, the petitioner is challenging the excommunication order. So I have been informed that it has been revoked, Lordship. But however, we are yet to receive the letter. So, Lordship, if this matter can come up on Monday and I may be allowed to produce that letter and the matter can be closed accordingly, Lordship.
Listed again on, what is Monday?
9th of October.
9/10.
Lordship, in the meantime, if the interim may
Yes,
continue.
yes, 9/10/2023. The interim order passed earlier shall continue till the next returnable date.
Much obliged, Lordship.
For orders, item number 39.
May it please your lordship. Lordship,
Yes,
can
ma'am.
you grant me a further time of 3 weeks to file my affidavit?
MS is married, the learned senior government advocate, 6 for 3 weeks' time
Yes, your
to file affidavit in opposition on behalf of the respondent number 1, 2, 3, 4, 5, 6, 7.
lordship. Till 5, your lordship.
Let us see, insofar as respondent number 6 to 18, okay, 6 to 18. 6 to, okay. 1, 2,
No, your lordship.
1, 3.
1, 3, 4, and 5.
2 is information
Because-
commission.
Yes, your lordship. And I see.
What was the last line? On behalf of the respondent number 1, 3, 4, and 5. Prayer is allowed, listed after 3 weeks. Then, stop. Return service report in respect of respondent number 2 awaited.
For admission, item number 13.
Okay. Yes, what is the gist? Are you still maintaining your children?
Yes, Lordship. They are all unmarried.
All unmarried?
Well,
So as per, Mr. Cham, as per the OM dated 13/7/2015,
Lordship.
the petitioner has to first submit an application
Yes, Lordship.
to the department.
That should be Lordship.
To the
Then-
department, and the department will forward it to
DC.
Deputy Commissioner for Inquiry.
Yes,
And thereafter submit the report to the department.
yes, and then the department will forward it to the AG, where we'll put the nominee in a DPO.
No, but kindly read the OM once again.
Lordship.
Therefore, from that para,
Last part, second paragraph.
yes.
Therefore, it is hereby reiterated that inclusion, change of nominee, which should also include post-retired spouse and children for the purpose of family pension. After the death of the pensioner, in respect of the 7 days, shall not be allowed to without proper inquiry by the Deputy Commissioner of the district. So, inclusion.
Any alteration, addition in the size of the family?
Any alteration, addition in the size of family should be immediately brought to the notice of the head of the office.
So this would also mean bringing in a new nominee?
Yes, Lordship. Because on top, Lordship, the inclusion and change of nominee.
Where?
On top. Therefore, it is hereby reiterated that inclusion, Lordship, that will be important.
Inclusion, change of nominee.
Yes. So
Change of nominee.
The case of the petitioner is for inclusion. So now, basically, Lordship, what the petitioner has to do is he has to make an application. Because her previous application was rejected. Because all these documents were not included, Lordship.
She has to
Make an application
present an application in the prescribed form.
in the best of form, yes, to the head of the department, that is DG. As per the order, Lordship.
So yes, Government Advocate, this OM will cover the case of the petitioner.
Yes, Your Lordship, here, but Your Lordship, in a similar case, Your Lordship, on 25th September 2023, Lord, in a similar case, there was a direction to the, as per this OM, Your Lordship, the petitioner was directed to approach the DC to verify for inquiry, Your Lordship. So the same direction may be passed, Your Lordship.
As far as my interpretation of the oil is concerned, Lordship, it has to be the HOD who has to forward it to the legal commissioner. Because I don't think the petitioner cannot go to the legal commissioner.
Yes.
Because this order, Lordship, nothing against the order, but the procedure that was, the direction that was given is take, Lordship. Because the petitioner by herself, she cannot go to the legal commissioner to authenticate my document. Unless there is a direction from the HOD.
If there's a direction from the court, because the DC is already a party in this case, Your Lordship, so.
Yes, Mr. Gauhati, you can kindly submit your case in a gist.
Lordship,
Just wait. Just in a gist.
Lordship, it is not denied that the petitioners they have been separated.
From your petition, let us see from your petition. Yes. What are the relevant paragraphs in your petition?
Lordship, the petitioner and let husband be what marriage in the year 1997. And out of the widowed, there are 4 children, 2 sons and 2 daughters. As of now, all of them they have attained the age of majority. And because of some misunderstanding between the petitioner and the late husband, they got separated and they were living separately. However, there was no formal divorce. And they are still husband and wife. And during that time, unfortunately, the husband expired. And the husband, while he was living, he was serving as NIBS. That NIBS means Naglite Armed Police Service, security officer at Toyang Hydro Electrical Project. And since the petitioner and her late husband, they were living separately, petitioner in the year 2000 has applied for the family pension. However, she was informed that the family pension of her late husband has been issued in favor of their 4 children, and she had no knowledge that their 4 children were carrying their family pension. So that is why she again reapplied that she is the legal wife of the late husband, the case BCA. And in the meantime, my application was also rejected by the Accountant General. So on receipt of the letter of the Accountant General by the DGP office, by letter dated F, that is annexure F, letter dated 17709, the petitioner was first informed to settle the matter amicably between the family members.
Which is that petition?
Page 16, annexure F. Page 16, annexure F. Page 16, 1-6. This is a letter written by the Office of the Director General of Police, informing the petitioner to first settle the outstanding issues and dispute among the concerned parties amicably before you present your case to the department for further necessary action.
And then what happens?
Then thereafter, the family members they settled the matter, and by an affidavit which was declared by the elder brother of my late husband. That is page 17, annexure G. This is the declaration made by the elder brother of my late husband, and where he has specifically stated that at Bara 3 and 4, Lordship, Three and 4, Lordship, married, Lordship, that whatever misunderstanding has been there within the family members of late VK Bisai has been amicably settled and agreed upon. 4. Settled. Amicably settled. There is some. This is not visible, Lordship. Amicably settled. 4. That the undersigned.
You take this. Tell him to fill up this.
Married have been amicably settled and agreed upon. And 4, Lordship, that the undersigned, representing the family of late VK Bisai, henceforth declare that we have no objection with regard to any claims made by Mrs. Avo, wife of late VK Bisai, as pension benefits in the bracket change of nominee. This was declared by the brother of late. So on the basis of that, I have submitted my representation to.
Where is your representation?
The next page, Lordship. 18. Page 18, annexure H. This is written to addressed to the Accountant General. However, a copy was also annexed to in the page 20, Lordship.
Yes. Now what was
also endorsed to the DGP, Lordship.
what was the reply of?
And so far, no action has been taken. So that is why the petitioner has no other option but to approach this honorable court, Lordship. Well, Federal Lordship, under the Family Pension Rule, CCS, Rule 16 of the Family Pension Rule, CCS, the first category for
Rule
16
family pension rule 16 CCS.
Let's see.
CCS. Page 8. The family pension.
CCS rules.
Yes.
Which,
under family
19?
pension.
Is it 1972?
Yes, yes.
1972?
Yes, yes. Under family
Yes,
pension. Pension rules.
Yes, wait, yes, wait. This says counting of service as apparentines. Rule 16.
Worship, I don't have a copy. If my worship may allow me to.
Give him. Let him trace out.
Yes, ma'am. 48. 3. 69. This one. Sorry.
Yes, confined.
Proceeding my, in my book, the relevant portion is missing.
This is the casualness you display in conducting your case.
Yes, I'm very sorry, Rajat.
If this court does not get any assistance from you,
Yes, Rajat.
then it may be difficult for this court to adjudicate matters.
And naturally, the pages, the relevant pages, rule 16 is missing. 15,
You have two books.
This is a compilation of the lordship. That's why it's very difficult to get it.
Yes, we have actually fixed your case for disposing today. You have just come casually shaking your hands.
I'm very sorry, lordship.
But we'll list it some other time. Though this court wanted to grant
Lordship,
you-
I will produce the
No, not today. List it again on Tuesday.
master.
On 10th.
11, lordship. 10,
At 11 is Wednesday.
Wednesday. Listen. 11, 12, lordship, please. I will. On 10, I will, or on 10, 9.
Okay, 9. Please come prepared, see your files, go through your files. Whatever relevant provisions of law you are mentioning, at least you should be able to satisfy the court on that.
I'm
You
very
should come ready.
I'm very sorry, lordship.
One of the AG's concern, I received a prior point, and my submission was on that line.
You come on 9th. We'll hear you. You come on 9th.
If without my affidavit, if I can supply a copy of this.
No, why you don't want to come on 9th?
No, I'll come, lordship.
Then?
If I may be allowed to produce Paras to the court, lordship. In spite of the.
You file there. Parawise means your gist.
I
Over.
received the Paras coming from the office of the accountant general, whereby my submission, lordship, as well as the OM of 15, it's reflected here, lordship.
Okay, so you are feeling lazy to file affidavit.
No, lordship, because of the short time, because I have to send for signature again, lordship. But my submission is on that line, lordship, on the OM.
Okay, you produce that on
Lordship,
Monday.
Lordship, yes.
Okay.
Because I'll make a affidavit, then it will be sent for.
Okay, you produce on
We'll take
Monday.
that, lordship, yes. Just-
Listed again on 9th, na? 9th. Please come, at least prepared, okay?
My apology, lordship.
Lordship.
For hearing, item number 14.
Yes, Mr. City.
May I bless your lordship?
Yeah.
My lord, this matter has been heard on the last 2 occasions. And both the councils have made elaborate submissions.
Okay.
Today is fixed for submission of written arguments by both the parties. And I believe both the parties are ready with the written arguments. So we are placing it today, lordship.
Okay.
Otherwise, so far as submissions are concerned, both the parties have made elaborate submissions. Exchange. We have exchanged our written arguments as well, lordship. Citations.
Just sum up, Mr. City.
Lordship, to sum up, they are raising so many points which are not relevant at all. The basic and the core issue is the Lok Ayukta do not have the jurisdiction to make inquiry in a service matter. And if at all they have the power, what prevented the Lok Ayukta to summon the concerned persons who are responsible for allowing us to remain in the service beyond the prescribed period? But the petitioners are in the service on the strength of the orders passed by the competent authority, and by now the release orders have already been issued in respect of the petitioners.
All,
Yes,
release order.
yes.
When are they retiring?
So I cannot do anything beyond what the authority says.
They are retiring May,
Yes.
May 2024.
And in order to attract the submissions which my learned friend has made, that where is the element of corrupt practice so far as the petitioners are concerned? And only when the element of corrupt practice is involved, then yes, whether it is a preliminary inquiry or a complete inquiry, thorough inquiry, they can do it. But then where is the element of corrupt practice so far as the petitioners are concerned? Petitioners must have done something so as to benefit them by indulging in the corrupt practice. What corrupt practice the petitioner has indulged? Nothing is there. Just because a complaint has been filed by an unknown person, the Lokayukta is very much interested to conduct an inquiry, and if at all any inquiry is necessary, what prevented them to call the concerned officers who are issuing the orders on behalf of the government lordship? Last time also we have furnished orders. Effective date is 31/5/2024 in respect of all the petitioners.
That is there on record, correct?
Yes, lordship. And if any inquiry is called for, lordship is well aware that government servants conduct rules, discipline and appeal rules, all these things are there. Those provisions can be invoked by the authorities and conduct the inquiry and impose penalty on the petitioners if it all their fault, at fault. But then forcefully, the Lokayukta is invoking jurisdiction in a service matter.
Yes, government advocate, you were also given some homework.
I wrote here, since affidavit in the possession has been filed by the state, so I'm relying on para 4 and 5.
Just wait, we have not heard you before. Let us just see your affidavit. Let us just see your affidavit. Respondent number
2.
Respondent number 2, okay. So, what is your affidavit, para?
Para 4 and 5.
This by Chief Engineer?
Yes, ma'am.
Chief Engineer, para 4 and 5.
Yes, ma'am. That is the only stand we have. Ma'am.
What is A role?
Acquaintance rule. Acquaintance rule, I believe. Nice.
Acquaintance rule.
Yes. In the acquaintance rule, lordship will find the particulars of all the government servants. When joined, when is due for retirement and all this. All particulars are shown in the acquaintance rule.
Para 4, 5 and 6.
I wanted to have a good puja vacation. This is my puja gift. 6 papers is not in the however, and saying does not require the petition name was accommodated by any committee as stated by the Okay. You have nothing much to say.
Yes.
Though you had, in fact, something more to say. Okay. So, okay, over. Heard Mr. C.T. Jamir, the Learned Senior Counsel for the petitioner, assisted by Mr. I become very scared to pronounce your name because I think I am Chin, assisted by Am Chin, Learned Counsel, and Mr. T.B. Jamir, along with Mr. I. Im Kong for the respondent number 1. Also heard Mr. E. Tibapom, the learned government advocate for the respondent number 2. Stop. Heard the parties outlined. Judgment in order reserved. Okay.
For hearing, item number 41.
Yes, what is this? Pension?
Yes.
What is your case?
One of the issue is that the petitioner was enrolled in the NAB on 10/5/1976.
Oh, that discharge and resignation?
No.
Have you any citation to differentiate that?
Directly, I do not have citation today.
Who is the counsel for the?
No, I've got one, but there is Armed Forces Tribunal, which is not binding before.
No, not binding, but the definition.
No.
Mr. Inchum, yes. What is?
I Googled it and I've searched lordship. I could not find lordship, my essential lordship. But lordship, I think my friend has also done a lot of cases in regard to army. He has been discharged. Where I don't remember exactly, but in one case, if it's not a criminal discharge on criminal ground, discharge on criminal ground, they are entitled to pension. If it's a lawful discharge. I don't know if there's lots of cases, so I remember. There, the court has given direction that he should be given pension because it was a lawful discharge. It was not a discharge on criminal ground for misconduct lordship, but it was a lawful discharge. So I remember it was an old case lordship. And then the has done some cases. Because lordship, I've done some research lordship, but the exact definition of the discharge, I could not find lordship. But lordship has had only not the regulation also. Keep the discharge format.
43.
Page 43, yes. Had this column been filled up, lordship, that would have solved the whole problem today, lordship.
Page 43 of?
The regulation. The title is at 43A.
Of the writ petition?
Yes, Lord. This is the discharge certificate, 43. And next page is the type copy lordship, 43A.
43, just wait, there's 43. Discharge certificate.
The reason for discharge is also not filled up motion. And the next motion, whether it is recommended for further employment in police department or other civil services. That one also is not filled up. Had this been filled up, Lordship, this complication could not have arisen, Lordship. Because the reason for discharge, they have to make mention why he has been discharged. Because, as I stated, Lordship, it was a criminal misconduct. They could have given a reason, but no reason has been given. Reason for discharge. And whether is it a time for employment, further employment, that column also not there. Had this been filled up, Lordship, the picture could have been more clear.
What has the government said on this? Whether you have actually made any comments on this?
We're saying that he was discharged on his own request, so that.
Discharged on his own request.
That in essence is a resignation, Your Lordship. That's why his past service has been.
Where is your law to support that? Where is your law to support that? Let us see.
See, I could not find, but I have one Kerala High Court judgment.
Let us see. You take me to the facts of this case, not the law. Take me to the facts. This is by the government.
Your Lordship is a short judgment.
There is in Kerala High Court, WPC, 2016, 3 KLT, WPC commandant, okay.
Second page, Your Lordship.
Second page. Yes, please.
The petitioner who got discharged from Assam High Court based on his own request claims pensionary benefit, treating his discharge from service as voluntary.
Which para you are reading, ma'am? 2. Para 2?
Yes, Your Lordship.
Para 2, okay.
The petitioner joined Assam Rifle, which is a paramilitary force under the government of India on 23/1995. In order to undergo infertility treatment, he requested for discharge from service, and accordingly, as per P1 discharge certificate, he was relieved from service on such and such on completion of 11 years, 5 months, and 12 days of service.
Yes.
The petitioner claims that since he has completed more than 10 years of service, he is eligible for pension, and in the light of CCS pension rules, hereinafter referred to as rules for short. The respondents have filed counter affidavits stating that the petitioner was discharged on the basis of his own request, which is the same in this case, Your Lordship.
No, don't,
And
you
that-
just continue properly.
Yes, Your Lordship. And that discharge from service on the basis of his request can only be reckoned as resignation. As per Rule 26 of the rules, a resignation from a service or post, unless it is allowed to be withdrawn in public interest by the appointing authority, entails forfeiture of past service, and therefore he is not entitled to pension. The respondent have produced such and such, which shows that at the time of relieving of the petitioner, as he had applied for discharge from service on compassionate ground, he was personally interviewed by the commandant. It was explained to him that no pensionary benefit would be admissible to him. They have also produced the undertaking certificate dated such and such, by which the petitioner certified that he understood that he would not be entitled to any pensionary benefit for a service rendered by him in the Assam Rifles. Petitioner was discharged from service on the basis of the recommendation of the commandant after issuing the certificate regarding inadmissibility of pensionary benefit for those discharged on request, and after obtaining an undertaking from the petitioner. Even otherwise, discharge from service on the basis of one's own request for his own personal purpose can only be treated as resignation. As the total service rendered by the petitioner was only 11 years, the relief from Assam Rifle cannot even be treated as voluntary retirement, since Rule 48A, which deals with voluntary retirement, requires a person to have 20 years of service for availing voluntary retirement. There is no provision under the rules which enables the petitioner to seek pension. The petitioner is not one who was compulsorily retired in the interest of government. Therefore, he does not come under the purview of Rule 38 39, 40, 47, or 48, 48 of CCS pension rules here.
This is CCS?
Yes, Your Lordship.
This is CCS?
Yes, Your Lordship.
CCS pension rules, 1972.
Yes, Your Lordship. In para 2, in the order it is mentioned here and hereinafter referred to as rule for short, the CCS pension rule.
Okay.
Yes, Your Lordship. And para 5, Your Lordship. I heard the learned counsel appearing for the petitioner as well as the learned standing counsel for the central government. From the documents produced on either side, it is clear that the petitioner was discharged on the basis of his own request when he did not have the requisite qualifying service for sanctioned pension. Moreover, in case where an officer is discharged on request before completing the minimum qualifying service prescribed for becoming eligible for pension, he can only be considered to have tendered resignation, which entails forfeiture of past service under Rule 26 of the rules.
Okay, just pause. How many years the petitioner has rendered service?
14
And what is the qualifying years?
For seeking voluntary retirement, it's 20 years, Your Lordship.
If I'm not mistaken, what my learned friend is referring, because the petitioner have not completed 10 years.
No, here 10 years, 10 years, more than 10 years.
So it is
More than 10 years.
11 years. Yes.
serving 14 years, 11 months.
Yes, 11, he has been serving, the petitioner has been serving 11 years, 14
So
months.
even for voluntary retirement, it's 20 years, Your Lordship.
Voluntary
So
retirement,
that's why he was not eligible for 20 years. He could have waited, but he resigned.
voluntary retirement, is it the qualifying service is 20
It's 20
years?
years, Your Lordship. It's 20 years, Your Lordship.
Well, from where you are actually like making that submission?
Yes, pension rule, Your Lordship.
CCS pension rules, let us see the CCS pension rules.
Yeah, Lord, what I'm trying to see is that
Oh, what is-
Rule 49, 2. Rule 49, 2 is clear.
In my affidavit.
CCS, what is this book? Oh, we cannot find anything here.
Page 121. Maybe
Just wait, let me first hear the government.
Yes.
After that only let me hear you, whether you have any case. 20 years, qualifying service 20 years. See, all of you are just coming. Well, what is that provision you were reading? A resignation entails forfeiture of service?
Rule 26, Your Lordship.
Rule 26, just
Yes, pension.
Rule 26.
The same confusion because different books have different. That is the problem.
Here, Rule 26, we do not find that for counting of past service. Forfeiture of service on resignation, let us see. Resignation from service of a post unless it is allowed to be withdrawn in public entails forfeiture. Resignation, it has been to take a proper permission.
me, if given the 5-10 minutes, Lordship, I can confirm from the office page. I've not had any affidavit, Lordship, in this case.
Okay.
So if I can get something from you. Definitely, I can answer.
We will see whether we can list it at 2.
Lordship, I have some because I've had affidavit in regard to those COVID employees, Lordship, and the country is coming up next week. So I have to take it down for that. Tomorrow,
Tomorrow, this court will be going out for inspection to Engsang. So, Rule 48. So we can have it Monday. But kindly come prepared, because I think I am also getting quite confused with Rule 40. Rule 48.
My learned friend has read on one judgment proceed. Here, the section of scrutiny is where the definition of voluntary retirement.
This citation.
Is in the citation.
Ha.
10 SC.
Correct.
514.
In which citation?
In the same citation which my learned friend.
No. This Kerala High Court.
Yes.
2000.
Para 8.
Even what about this citation? No, 2004 4 SCC. Have you gone through all this in Oli?
Yes, sir.
2005 8. Is it not relevant?
It is relevant, but though it is
2009 10 SCC 514 and 2004 9 SCC. The Apex Court has elaborately considered the difference between voluntary retirement and discharge from service. This might be of some assistance to the court, which is what she was asking. Discharge and voluntary retirement.
You're reading Rule 48.
yes, Your Lordship.
Rule 48 of the CCS pension rules.
Yes, Your Lordship.
48.
If I may, Your Lordship.
I think some extensive work has to be done in this case. It appears very simple, but it's not very simple as the learned counsel for the petitioner has submitted. Yes, read.
Rule 48A, retirement on completion of 20 years qualifying years. At any time after a government servant has completed 20 years qualifying service, he may, by giving notice of not less than 3 months in writing to the appointing authority, retire from service.
So now what is the difference between retirement and discharge? Yes. Retirement, discharge, voluntary retirement. Yes, what does the Honorable Supreme Court says, Mr. Ncham?
But it speaks only about the resignation and voluntary retirement. It doesn't speak about the discharge. And then, like I said, Lordship, I have.
Here actually it says between voluntary, consider the difference between voluntary retirement and discharge from service.
Yes. And in that judgment, Lordship, I've gone through. Nothing speaks about the discharge. Only voluntary retirement and resignation. Lordship, that's why I was saying that I could not find it specifically with regard to discharge. But there were some instances, some cases, where lawful discharge, the person is never mentioned.
Yes, Mr. MT, it is your case unless you satisfy this court. Maybe I think I will have to finish up. I will not have to give you any relief unless you satisfy this court.
I can get instruction also, Lordship.
Get instructions.
AG offices.
Because it is your case, it is you, I am actually doing your homework. It is for you to satisfy me. Next time if you cannot, then I think maybe we will not take up this matter. It is your case. Now the question of discharge and resignation has come up, so you should be able to satisfy this court. It is your duty.
My lord, discharge certificate is issued by the authority, not by me.
That is undisputed. That is undisputed. That is undisputed. We know that the petitioner has been discharged on his own request. But now, on the basis of the discharge, you are claiming pension.
That question will come into play.
So whether on the basis of your discharge you are entitled to pension?
Yes.
You will have to satisfy this court. That is your case.
Yes.
That is why when actually the issue of resignation is brought out by the learned government advocate, I am asking you to differentiate that. Discharge and resignation.
My lord, the thing is this. The government have issued discharge certificate. They cannot take it as a resignation.
Are bhai.
In their affidavit also, they are saying that due discharge. They are not saying that it was a resignation. Yes. That is the whole issue.
That is not the whole issue. The whole issue is whether on the basis of your discharge you are entitled to pension. That is the issue.
Yes.
Yes, so where is the law?
That is Rule 49, 2.
What does it say?
If it is below 10 years, he will be entitled only for gratuity. But the moment he completes 10 years...
That is retirement. Is it retirement?
It is.
Retirement, it is to do with retirement. Yours is not retirement. Yours is discharge.
Rule 5 is very...
You are confusing. The more you submit, you are confusing the court more and more. And I think from the day one, I have been telling you to satisfy this court on this issue. Yes, Mr. Nchum, I think lastly we have to bank on a neutral institution.
I'll get instruction from the office of the AG.
Yes, I think you will have to call one officials of the AG who is familiar with all this.
Yes,
and then you will have to actually know everything from him, discharge, resignation, whether one's own discharge, whether a person is entitled to pension, and if so, under what rules.
In fact, last time when I sought for instruction, since this is issue between the state and the petitioner, so our role has not come. So we have to find
Now actually the court wants your assistance.
Yes, definitely. I'll request the office of the AG to write an official.
Not right, to let him come and to sit with you to explain. I think some proper explanation is required. Because here the issue is actually the petitioner says that he has been voluntarily discharged and therefore he is entitled to pension since he has served for more than 10 years above. The learned government advocate says that no, it is resignation. Therefore, resignation entails forfeiture of service. So, by virtue of that, the petitioner is not entitled to pension.
Because, like I said, Lordship, in spite of my best effort, there is no decision of the Atlas Court, Lordship, as far as discharge.
No. See, Mr. Ncham, decision maybe there it is there, but we are actually not getting it as we desire. But actually, see. This can be properly explained by an official of the Accountant General.
Yes.
What is the difference between discharge, resignation? Whether a person who has been discharged, voluntarily discharged from service after serving more than 10 years is entitled to pension? What is the difference between discharge and resignation? At least you tell him and then actually if he actually gives you the answer to the question, you tell him to justify as per the rules. So that at least we can get some proper knowledge.
So, Lordship, if the necessary order may be issued, Lordship, directing the office of the AG to clarify on this, so that it becomes official, Lordship. That can be placed before court. So, any official communication that is received, that can be placed on record.
Mr. Imti, Longchar, the learned counsel for the petitioner,
Okay.
and MS Inaholi, the learned government advocate, and Mr. N. Muzui, the learned standing counsel for the respondent number
6.
6. That is respondent number 6. Yes. In the course of the hearing of the case, it has become necessary for this court to request the learned standing counsel for the respondent number 6 to place the answer to the following queries raised by this court. Okay. 1. Whether a government servant who is voluntarily retired from service after serving for more than 10 years is entitled to pensionary benefits. What should be the other one?
Whether a person applying for discharge.
Just wait. Pardon?
Whether the person who has applied for discharge is entitled for pension.
After completion of 10 years.
Whether the person, we just wait, don't wait.
Yes.
Whether a person who has sought for discharge from service.
No, that I think we have really, what was the question? Who has been voluntarily discharged? Who has been voluntarily discharged? Not retired, who has been voluntarily discharged
On his own request.
from service on his own request is entitled to pensionary benefits. That will suffice.
After 10 years. After 10 years.
After 10 years we have written, no? We have written.
I think also that will cover.
My lord, yes.
Basically, the charge of the matter is that only. Because the petitioner say I completed 10 years.
On discharge.
I've been discharged on my own request, so I'm entitled for pension. And he's referring to rule for P2 and then
49.
49. So I'll get a clarification on that and I'll have a discussion with the Office of the Economy.
Yes. Let us also inquire this whether a discharge from service and resignation from service are one and same.
Yes.
Number 2, whether a discharge from service
On his own request, maybe.
and a resignation from service is one and same in regard to the entitlement of pension.
No.
Okay, let us get that information at least. Since Mr. Imti, I have been shouting, you are not getting me any answer. The learned standing counsel for the respondent number 6 is directed to place the answer to the above queries after minute discussion with the respondent number 6. Okay? Listed again on?
18. So 17. October. Because I did time.
Okay, listed again on 17/10/2023. In the meantime, I think you have to do further extensive research also. You are actually, Mr. MT, before the court, you are very obedient. But once you go back home, I think you don't do your proper homework and you just come like that.
Lordship, Karthak was saying a story about that.
What did he say?
He was telling me to go and read Rick Van Winkle.
Okay. Yes, a copy of the order shall be furnished to Mr. N. Muzui, the Learned Standing Counsel for the respondent number 6. Positively by 6/10/2023. Okay.
I'll definitely get there first.
Please do that. Please do that.